Welcome to this session of Forensic Medicine. We are going to discuss on topic evidence. What is evidence? All statement or documents which the court permits or required to be made before it by a witness in relation to matters of fact under inquiry. The evidence is broadly categorized into two main groups. 1. Medical evidence. This is defined as evidence obtained through medical examination, analysis, and expert opinion. It includes oral evidence, documentary evidence. 2. Other forms of evidence. Physical evidence, chemical evidence, digital evidence, psychological evidence, biological evidence, ballistics evidence, oral evidence, also known as testimony, means all statements, oral or verbal, which the court permits or requires to be made before it by witnesses, in relation to matters of fact under inquiry. Types of oral evidence. 1. Direct evidence. When the witness had directly seen the crime or had felt it by any of their senses, it is called direct evidence. Example, a street vendor saw a murder in the street. 2. Indirect evidence. When the witness did not directly see or experience the crime, but some other fact or information suggests the commission of the crime. 2. Circumstantial evidence. Witness did not see the actual crime, but some related fact observed by them indicates strongly towards the commission of crime. Example, witness saw the accused with a knife just before the murder. 2 billion. Hearsay evidence. The witness only heard about the crime from someone. Example, told that B had committed the crime. Documentary evidence. Documentary evidence is defined as any evidence that is produced in a written, printed, electronic, or recorded form, without requiring any oral testimony. There are several types of documentary evidence. These include 1. Medical certificates. 2. Death certificates. 3. MLC medico-legal case reports. 4. Dying declarations. 5. And dying depositions. The importance of documentary evidence lies in the fact that it permits cross-examination, making it a crucial component in legal proceedings. Comparison of dying declaration versus dying deposition, highlighting their key differences. 1. Geographical scope. Dying declaration followed in India. Dying deposition followed in Western countries, for example, the United States. 2. Nature of the statement. Dying declaration. It is merely the recording of a statement of a dying person. Dying deposition. It is a full-fledged court procedure at the bedside, also known as court by the bedside. 3. Recording authority. Dying declaration. It can be recorded by a magistrate or doctor or police officer or panchayat head or relative. Dying deposition. Recorded always by a magistrate. 4. Presence of accused and lawyer. Dying declaration. The accused and his lawyer need not be present. Dying deposition. The accused and his lawyer have to be present. 5. Oath. Dying declaration. Oath is not administered. Dying deposition. Oath has to be administered. 6. Cross-examination. Dying declaration. Cross-examination is not allowed. Dying deposition allowed. 7. Leading questions. Dying declaration. Leading questions are not allowed. Dying deposition allowed. 8. Value if victim survives. Dying declaration. If the victim survives, it loses its value and is not admissible in the court of law, but it acts as corroborative evidence. Dying deposition. If the victim survives, it retains its value. Physical evidence refers to any material object that can be physically or chemically analyzed during a criminal investigation. Chemical and toxicological evidence involves the analysis of chemicals, drugs, poisons, and other substances recovered from crime scenes or biological specimens. Biological samples such as blood, urine, tissues, or stomach contents are collected and examined through toxicological testing. Examples of toxic substances include organophosphate insecticides, cyanide, arsenic, alkaloids, and metallic poisons. Digital evidence. Digital evidence involves the recovery and investigation of data found in electronic devices. It's a crucial field in modern investigations, including mobile phones, computers, and laptops, emails and messages, CCTV footage, various storage devices. Psychological evidence. This field delves into the mental state of individuals, offering crucial insights into their behavior and potential for committing crimes. First, we have profiling and behavioral evidence. This involves analyzing a criminal's behavior patterns, then lie detector techniques. Specifically, polygraph tests or lie detector tests are used as an investigation. Biological evidence. Biological evidence refers to any sample of biological material from which DNA can be extracted. It's a cornerstone of forensic science. Let's explore the key methods and applications. 1. DNA profiling 2. Blood typing and serological analysis. Ballistic evidence. Ballistics is the study of firearms, ammunition, and the motion of projectiles. Types of ballistic evidence: bullets/projectiles recovered from body or scene cartridge cases. Shells. Firearm/gun gunshot residue. GSR. Wadding, pellets, fragments. Chain of custody. The chain of custody is a secure and reliable system that maintains the record of electronic evidence from the time it is seized until it is produced in court. It's a critical process to ensure the integrity of evidence. Let's walk through the chain of custody process step by step. 1. Seizure and collection. First, electronic evidence is identified and carefully seized from its location. This is the initial point where the chain begins. 2. Proper custody. Once collected, the record of this evidence is maintained in a secure system with appropriate access controls and audit trails. This ensures its safety and accountability. 3. Documentation. Detailed documentation is crucial. This step involves recording the details of each person who handles the evidence, including their name, role, the date, time, purpose of handling, and their signature or ID. 4. Secure storage. The evidence is then stored on a protected device in a designated location with controlled access. This prevents unauthorized access or tampering. 5. Transfers. Should the evidence need to be transferred, every single transfer is meticulously documented. This includes the date, time, who it was transferred from, who it was transferred to, and the exact purpose of the transfer. 6. Production in court. Finally, the evidence is produced in court, backed by a complete and unbroken chain of custody record. This unbroken chain is vital for its legal standing. Thank you. Subscribe for more videos.